Good morning, everybody. On behalf of the team here at ARAG and also the team at Stephensons today, a very, very warm welcome to you all to the second of our Talk to the Expert series. This one obviously focusing on care, and I do hope you are all keeping safe and well during this time. So here's the agenda. Obviously a very brief intro from me. Then we'll move across to Adam, who is a frequent face on our webinars, who will look at the employment and key changes in the sector.
Morning everyone, my name is Adam Pennington. I'm a Senior Associate in the employment team, so I assist both companies who are looking to defend claims or prepare policies and procedures, and we also assist employees who are looking to pursue claims at tribunal. So just a gentle reminder, the job retention scheme comes to an end on the 31st of October, so I just wanted to quickly recap on some of the main points. So it's been recommended to seek agreement from those who are placed on furlough or written agreement. Employees can of course work elsewhere while on furlough, but not for organisations linked to the employer. Employees can take annual leave while on furlough and carry untaken leave up to 4 weeks into the next 2 years. Employees may be switched from sick pay to furlough and vice versa. However, there's no right to statutory sick pay while on furlough. Furloughed employees can be brought back part-time, and employees are entitled to statutory sick pay if they've been told to isolate under the test and trace system. From the 1st of August, employers were asked to contribute towards national insurance and pension contributions. From the start of this month, the government will reimburse only 70% of salary, a maximum of £2,190 per month. Employers must top up to at least 80%. From the 1st of October, the government will only provide a reimbursement of 60%, and on the 31st of October, of course, the furlough scheme will come to an end. So we have a number of clients in the care sector, and things, I suppose, which were previously taken as read as far as policies and procedures are concerned. With COVID and the introduction of remote working, this has caused some difficulties for people trying to work through the process, and a common question we get asked, and a common area where some policies and procedures are not followed correctly, is where they're asked to carry out those procedures remotely. So the first thing to bear in mind is that if someone's on temporary leave or furlough, they can still raise a grievance, and they can take part in a disciplinary or grievance investigation or hearing. So deciding whether or not those proceedings should go ahead, it's important to bear in mind that disciplinary and grievance procedures must always be fair and reasonable. During the coronavirus pandemic, they must be carried out in a way that follows public health guidelines, of course surrounding social distancing and the closure or phased reopening of certain workplaces. It may be helpful for employees to consider their overall policy on how they handle disciplinary and grievance procedures, and this is something that we've been asked to look at in light of certain sectors introducing more remote working. Many organisations and employees will of course be facing additional pressures, and there may be practical challenges to holding meetings, but we must bear in mind that procedures must still be taken forward without unreasonable delay. Employers should try to find a safe, fair and reasonable way to go ahead with procedures, and if this is not possible, they should consider if it might be fair to suspend a procedure. So, considering the circumstances of each case, of course it's important for all employers to look at the individual circumstances and sensitivity of each case when deciding how to proceed. For example, they may consider if it may be something urgent, such as a disciplinary allegation of gross misconduct or a grievance about unlawful harassment, or for relatively minor disciplinary issues, it may be more appropriate to consider if this could be reasonably dealt with at a later date. If it's a grievance or a disciplinary issue about an ongoing situation, it's important to consider whether a delay might make the matter worse. If the case may result in an employment tribunal claim, it's important to bear in mind that there's a quick turnaround with employment law cases. Generally speaking, an employee will have 3 months from the date of a discriminatory act or a date of dismissal or a date of harassment to pursue the claim. And therefore, if the time limit ends before the grievance or disciplinary meeting is held, delay in the case may result in an employment tribunal claim being made, which might have otherwise been avoided had we gone through that procedure sooner. The employer should talk through the options with everyone involved before deciding whether and how to proceed. This includes the employee involved in the procedure, their representatives or companion, if there is one, any other people involved, for example, the manager chairing the meeting or witnesses who they may need to attend. This will, of course, help the employer make an informed decision based on everyone's circumstances. When talking through the options, it's important for the employer to consider if anyone has a good reason for wanting the procedure to either go ahead or be suspended, has concerns about holding the meeting either in person or remotely, has concerns about how the employee can be fairly accompanied at the meeting. Going through a disciplinary or grievance procedure can be stressful at the best of times, and employees might be facing other stressful circumstances during the pandemic. Employers, of course, should therefore give careful consideration to the health and well-being of employees when deciding whether and how to proceed. Of course, if the workplace is open and we can observe social distancing, it may be possible to consider a face-to-face hearing that can be arranged. If the employer does go ahead with a face-to-face meeting, it's important that the chosen companion can also attend that meeting in person if the employee wishes. If the face-to-face meeting cannot be safely arranged, or if anyone has another reasonable objection to holding the meeting in person, it should be considered whether it's possible to carry out that procedure remotely in a fair way. If this is not possible, it may be appropriate to suspend the meeting. A common question for us, therefore, is what do we need to consider if we were to carry out the procedure remotely? So video meetings may need to be used for any investigation interviews and hearings if a procedure is carried out remotely, as long as the procedure is still fair and reasonable. It's important to consider if everyone involved has access to the technology needed for video meetings, for example, the necessary equipment and internet connection. Anyone involved has any disability or other accessibility issues that may affect their ability to use video technology. It's possible to get hold of all the evidence needed for the investigation or hearing, for example, records or files that are kept in the office. Any witness statements or other evidence can be seen clearly by everyone involved during an interview or hearing. And if it's possible for the person under the disciplinary investigation or who raised a grievance to be fairly accompanied during the hearing. And of course, the right to be accompanied, which is a legal right, doesn't change even if the hearing is taking place remotely. The employee will always have a right of appeal, regardless of whether or not this is conducted face-to-face or remotely. So that's appealing a decision to dismiss or other disciplinary sanction, or appealing the outcome of a grievance procedure. The employer must follow a fair appeals procedure, taking in the same considerations as for carrying out a disciplinary or grievance procedure during the coronavirus pandemic. So with all that in mind, just moving on to the next slide. And some of these we've noticed particularly in the care sector. So these are claims that, of course, have always existed, but with what's happened with Corona and the furlough scheme, we're seeing a surge in these claims in particular, and just a different slant, if you like, on the way in which they're being brought. So the first one, unfair dismissal. So unfortunately for certain industries, the knock-on effect of Corona has meant that they've unfortunately had to look at making redundancies. We've seen a number of claims come through where employees are challenging the decision to make them redundant on the basis that the employer had failed to consider extending furlough, for example. There's no obligation, of course, on the employer to put staff on furlough. It's entirely up to the employer. but the employer must consider all suitable alternatives to dismissal. So what the furlough scheme does is introduce another alternative to that. And so cases that we have going through at the moment, a number of which we're defending, we're yet to see how the tribunal will consider that. If the company has evidence, of course, to show that putting a member of staff on furlough would be futile, because the outcome is still going to be redundancy, that's a safer way for that employer to protect themselves. In certain circumstances, there is no evidence that they've considered that, and so it's in that area we're seeing some of these unfair dismissal claims move through. Fairness of the procedure. So I've just spent some time talking about the fairness of conducting a disciplinary procedure and remotely, and each time for the employer to consider, well, am I able to review all the evidence? Are all the relevant witnesses able to attend remotely? And what the employer needs to bear in mind is if the answer to those questions are no, the outcome of any procedure, particularly if there's a risk of it resulting in dismissal, the failure to follow a fair procedure can sometimes disturb the overall decision to dismiss. Redundancy. So of course, redundancy is a potentially fair reason to dismiss someone. And again, with what's happening at the moment, we are seeing a number of claims come through from fair dismissal on the basis that individuals have been made redundant. Of course, companies need to ensure that there is a genuine redundancy situation, and having established that that's the case, must ensure they go on to follow a fair procedure. Very briefly, if there is more than one individual being made redundant, we must ensure that we're applying selection criteria which is objectively chosen and fairly applied. We need to ensure that the employee is warned and consulted about the redundancy, whether if there is a union, the union's view was sought, and of course whether any alternative work was available. So redundancy procedures in themselves can be quite difficult, let alone trying to conduct something like that remotely. Constructive and fair dismissal. So this is, in order for an employee to succeed with this claim, they must be able to demonstrate there's been a fundamental or repudiatory breach of either the express terms of the contract or the implied term of trust and confidence, and they've resigned in response to that fundamental breach. These are notoriously difficult claims for employees to succeed with because of the hurdles that they need to get over. However, these claims can arise in situations such as employers failing to follow fair and reasonable procedures. So just going back to the example of conducting a procedure remotely, if a key witness for the employee wasn't available to attend, but the employer decides, particularly perhaps in the care sector, that it's in the interests of the safety of the residents to proceed with that procedure, failing to interview key witnesses before making that decision, could result in a fundamental breach of trust and confidence, and the employee may resign in those circumstances. Similarly, again, in the care sector, failing to follow government advice on social distancing, ensuring that PPE is available, these sorts of things are capable of amounting to fundamental breaches of trust and confidence. And the risk there is that an employee with 15 years service may not necessarily need to be dismissed. They themselves would resign in response to their employer's failures, and of course the greater the length of service, the higher the value of the claim. Whistleblowing in particular, again in the care sector, this occurs when someone discloses information which is in the public interest, and this tends to show that either a criminal offence or the health and safety of an individual is at risk, or there's a risk of damage to the environment, or a company is breaching the law in some other way. So a good example in the care sector is that individuals raise concerns or blow the whistle about the care available for the residents, or a company's alleged failures to follow government advice. In order for the claim to complete, the employee then needs to show that they've been put to a detriment in some way. So they've blown the whistle, and consequently they have been dismissed or put on a performance improvement plan, but they notice some disparity between that decision and the fact that they've never had any performance concerns, and so that employee will assume, unless it can be proven otherwise, that that detriment has been caused by them blowing the whistle. Victimisation works in a similar way to whistleblowing, but this occurs when someone does what's called a protected act. And as a result of doing that, they're put to a detriment in some way. So a protected act requires the employee to either commence proceedings under the Equality Act, so this is any form of discrimination, or giving evidence as part of those proceedings, or doing any other thing for the purposes of the Equality Act. So, for example, disclosing to their employer that they have a disability or that they're vulnerable, and if they are put to a detriment in some way, they will have a claim for victimisation. So in the care sector, for example, someone is unable to attend work because of their disability or the disability of someone else who they're caring for, and this may make them unable to attend a particular shift. If they can prove a causal link between that disclosure and any subsequent detriment, they will have a claim for victimisation. Just to put these claims into some context on the next slide, this gives you an overview of the awards that the tribunal can make. So unfair dismissal, currently the basic award, 16,140. Unfair dismissal compensatory award, that just shows you the maximum award that the tribunal can make, what a week's pay is calculated at. But more importantly, just tying this back to the whistleblowing claims, for example, dismissal for health and safety reasons, there's no cap on that compensation. Dismissal for making protected disclosures, again, no limit, nor is there any limit necessarily for discrimination. Breach of contract is capped at £25,000. It's important to bear in mind in the tribunal that we're in a cost-neutral environment. I would say about 50% of the cases I'm involved with where I'm defending companies, including those in the care sector, we're against litigants in person. That's because they know that win or lose, they're not going to be asked to cover the company's legal bill. Unless that employee was to act vexatiously or frivolously, it's very unlikely that a tribunal will award costs against them, win or lose. It's even less likely due to the fact that they are litigants in person, and the tribunals are far more lenient with them. Just moving on to the next slide then. Reducing risk. So bear in mind, as I say, that we're in a cost-neutral environment. One of the ways in which we can look to prevent the claim progressing further is making applications to strike claims out on the basis that there is very little merit. The best way that we can do that is by having documentary evidence to rebut some of these claims. So reducing the risk of some of these claims, or certainly helping prepare a robust defence, it's important to consult with staff. So any decisions which have the potential to affect staff, either on an individual basis or collectively, it's important that we don't make unilateral decisions. That's more likely to result in claims of constructive and fair dismissal where individuals are alleging a breach of trust and confidence, or discrimination. For example, that unilateral decision may put a particular person, someone who suffers from a disability, at a particular disadvantage. Obtaining written agreement. So if a course of action is agreed with a member of staff, make sure that we obtain their written agreement where necessary. A good example in the current context is a furlough agreement. Follow up any substantive decisions in writing. So this reduces the risk of an employee suggesting that a decision was motivated by them blowing the whistle or doing a protected act or for some other discriminatory reason. I'm currently assisting a care home at the moment who are looking to defend a claim that an individual has brought alleging that she was sent home by the care home because she was pregnant and therefore only paid her statutory sick pay. And the case rests on whether or not it was the care home who sent her home or whether or not she herself chose to self-isolate. And the difference between that will be she either has a particularly strong claim for pregnancy discrimination and an unlawful deduction to her wages, or the cases fall entirely if it can be shown that she chose to self-isolate. This reinforces the need for documentary evidence, because in this particular case, we don't have documentary evidence to prove either way. And what will happen is that will turn on a person's version of events against another's. And that's always a tricky position to be in front of the judge. And lastly, or moving towards the end, it's always important to have a redundancy policy procedure in place, a robust one, which we can assist in drafting, and certainly a whistleblowing policy. By allowing an employee to raise concerns through a whistleblowing procedure, this reduces risk to the employer, so it reduces the risk of someone sharing these concerns and potentially damaging the reputation of the employer. And lastly, it's important to seek professional advice. So it's been a bit of a minefield for employers recently, particularly with what's gone on, and with the talk of a second lockdown, etc. It's something which is going to continue well into next year. So there is no harm in picking up the phone to an advisor to double check that the policies and procedures and the processes being followed are correct.